Welcome to OnRisk, rapid legal lessons for policyholders, a K&L Gates podcast that discusses insurance topics from a policyholder's perspective. My name is Jeff Marr, and I'm a partner in the Insurance Recovery and Counseling Practice Group here at K&L Gates. Joining me today is Lucas Tanglin, a partner in our Pittsburgh office, and Raymond Yamin, an associate in our Newark office. Now, Lucas and Raymond both co-authored an article with me for Reuters on the Russia-Ukraine conflict and insurance for state-sponsored cyber attacks. And that's what we're here to talk about today in this podcast. So thank you both for joining us today. Now, Lucas, I want to start off with you. A few weeks ago, President Biden cited evolving intelligence that Russia was considering potential cyber attacks in response to sanctions that have been imposed by the United States and their allies. And it immediately made me think of the NotPetya cyber attack a few years ago. Can you tell us a little bit more about that attack and why it's relevant to our discussion today?
Sure, Jeff. The NotPetya cyber attack was a massive and destructive cyber attack that occurred in June of 2017. The White House, shortly after that attack, referred to NotPetya as the most destructive and costly cyber attack in history. The impacts of the NotPetya attack were first felt in Ukraine. The first entity to be hit with the NotPetya cyber attack was a Ukrainian company. What the NotPetya cyber attack was capable of doing was bringing a company's or an entity's computer systems to a standstill. It could make a company's computer files completely inaccessible. It could completely crash critical business software. So we saw in NotPetya this attack spread throughout Ukraine initially and throughout the globe, hitting major global companies and in some instances truly bringing their operations to a standstill. We saw companies impacted in industries such as food production, global shipping, just a massive, destructive cyber attack with huge economic consequences. One notable thing about the NotPetya attack as I mentioned, that the first impacts were felt in Ukraine. And then we did eventually hear from the White House an attribution of the NotPetya attack to Russia. The White House called NotPetya part of the Kremlin's ongoing effort to destabilize Ukraine. So I can understand why the current situation in Ukraine brings to mind this past experience with the NotPetya attack.
And Lucas, that brings me to my next question. So you obviously had a significant amount of losses arising out of this attack. How did insurers respond to claims for those losses?
Yeah, and we don't know, how every insurer responded to claims that were made, but we do know how some insurers responded. Certainly there were policyholders, large companies that filed claims with their insurers under insurance policies, including property insurance policies, seeking to recover for the damage to computer systems themselves and maybe more importantly, damage for the economic interruptions that NotPetya caused these companies to incur. And we do know that at least some insurers, when they received these claims, denied coverage, and sometimes based on a type of exclusion in the insurance policy called a war or warlike action exclusion. And the wording of these exclusions can vary, but what some policyholders experienced was their insurers saying, because NotPetya has been attributed to the Russian government as part of a conflict with Ukraine, the insurers determined that these exclusions should be implicated and operate to bar coverage for NotPetya based on that attribution to the Russian government as part of that Ukraine conflict.
So Raymond, that brings us to you. There were a number of court cases that arose out of the NotPetya cyber attack, and one of those involved Merck, the large U.S. pharmaceutical company. Tell us a little bit about the Merck case.
Thank you, Jeff. Well, as you alluded, Merck was among the many companies that were affected by the NotPetya attack. According to court records, Merck's computer system became infected by the NotPetya malware on June 27, 2017. And according to their estimates, approximately 40,000 of its computers were damaged, with losses in excess of $1.4 billion. It's a huge number. Following these losses, Merck attempted to secure coverage from its insurers. And as you might expect, the two sides took very different positions on the issue of coverage. On one end, the insurers argued that because NotPetya was reportedly an attack that has been attributed to the Russian government, the war exclusion in the policies precluded coverage. And more specifically, the exclusion at issue barred coverage for losses caused by hostile or warlike action, and I'll quote, by any government or sovereign power or government authority maintaining or using military, naval, or air forces. On the other end, Merck took the position that the exclusion could not apply based on this language. How could an exclusion apply that talks about military, naval, air forces to a cyber attack? Likewise, Merck also argued that it purchased $1.75 billion in property insurance with coverage for loss or damage resulting from destruction or corruption of computer data and software. And this is precisely why they bought this coverage. Merck ultimately sued the insurers in the New Jersey Superior Court, which, if you're unfamiliar, is a trial court level in New Jersey in 2018. In January 2022, roughly 4 years after Merck filed its lawsuit, the New Jersey Superior Court granted Merck's motion for summary judgment.
So tell me a little bit more about that decision, Raymond. Why did the court grant Merck's motion for summary judgment?
Sure. Well, there are a couple of interesting points from the court's opinion. First, the court concluded that for many years, insurers have been aware that cyber attacks, and more specifically, state-sponsored cyber attacks, were a rising threat. Despite this increased awareness, the court pointed out that the language of the war exclusion, and I'll quote, has been virtually the same for many years. And as a result, the court concluded that Merck had every right to anticipate that the exclusion applied only to traditional forms of warfare, not cyber attacks. And the second interesting point is that the court remarked that to date, no courts have construed war exclusions so broadly as to preclude coverage for cyber attacks based on a purported nexus to traditional warfare. That just hasn't happened. And so on this basis, the court granted Merck's motion for summary judgment and concluded that the war exclusion did not apply. I'll say that the insurers have appealed the court's order to the New Jersey Appellate Division, so the Superior Court's decision may not be the last word on this issue.
Thanks, Raymond. Now, this Merck decision is really important because it's the first published court decision that's interpreted the war exclusion in the context of a cyber attack. And it's important not only for policyholders who have property insurance policies, which was the type of policy at issue in the Merck case. It's also really important for policyholders who have standalone cyber insurance policies because those policies tend to have very similar war exclusion in them. And so as you might imagine, the fact that a lot of big insurance companies were taking this position with respect to the war exclusion in connection with the NotPetya attack caused a lot of concern among policyholders with cyber insurance policies when those decisions were reported. And I got a lot of calls at the time. There was a New York Times article written about the subject at the time, and there was generally a lot of concern among policyholders that insurers faced with losses arising out of a state-sponsored cyber attack would raise these war exclusions and use them to try to deny coverage. But then an interesting thing happened. I started to see more and more cyber policies that had these war exclusions in them, but that also had what was called a cyber terrorism exception to the war exclusion. And these exceptions varied from policy to policy, but there was a lot of similarity, and some of them were written quite broadly to accept or restore coverage for a cyber attack that was initiated with the intent to cause harm in furtherance of political, social, religious, or economic intentions. And so that gave policyholders some comfort because even if the war exclusion applied to a cyber attack, they could argue that this cyber terrorism exception restored coverage. Now, fast forward to today, and what I'm seeing during renewal season is a lot of insurers who seem to be trying to pull back some of that coverage, presumably with the Russia-Ukraine conflict and cyber attacks arising out of that conflict in mind. And so policyholders should be very aware of kind of what coverage they currently have, whether they have a war exclusion, and if so, Do they have a cyber terrorism exception to that war exclusion? But they should also pay very close attention to what happens in renewal, and in particular to any changes to either the war exclusion or the cyber terrorism exception that might impact their ability to argue that they have coverage for a state-sponsored cyber attack rising out of the Russia-Ukraine conflict. And so I'll end it with that. Thank you for listening to this episode of OnRisk. I hope you found our discussion helpful. To find more insurance-related content, visit the K&L Gates Hub at www.klgates.com/hub. The Hub is a digital destination for timely insight on critical issues at the intersection of business and law. You can also visit our website, www.klgates.com, to learn more about our insurance recovery and counseling practice group, or to connect with one of our lawyers. Thanks again for listening, and be on the lookout for the next episode of OnRisk.